In 1992, Justice Umesh Chandra Banerjee of Hon'ble Calcutta High Court delivered a landmark judgment that granted legal protection to the area of East Calcutta Wetlands and Wet Recycling Region. Much before the East Calcutta Wetlands was designated as Wetlands of International Importance, a public interest litigation was filed by a Kolkata-based NGO, People United for Better Living in Calcutta Insured Public, in 1991 in the Honorable High Court at Calcutta. The petition challenged the Government of West Bengal's plan to set up a World Trade Center by reclaiming a portion of wetland. In the petition, Article 51A and Article 21 of the Constitution of India were quoted. The legal argument was that these articles can be interpreted as including the protection of lakes and must also bind the government and its personnel to protect the wetlands, as the citizens have the fundamental right, the right to live in environmentally safe and pollution free conditions. The PIL asking direction of the state authorities to protect the wetlands and maintain their character, in particular preventing their reclamation as well as change in land use. The petitioners' arguments were the proposed World Trade Center was projected as a step towards economic and infrastructural growth, but was in reality a public initiative without central government approval. That time, proposal of 14 World Trade Centers all over the country was considering by the central government, but Kolkata's World Trade Center was not in the list of pre-approved stage. The East Calcutta wetlands serve crucial ecological functions like natural sewage treatment, oxygen production, maintain microclimatic condition, habitat for flora, fauna and migratory birds, livelihood for thousands through pisciculture, horticulture and agriculture. Loss of wetlands would lead to flooding, pollution, health hazard, collapse of natural waste recycling system, damage to Kolkata's microclimatic condition, displacement of marginal families who depends on wetland for livelihood. The state governments claim that the World Trade Center would bring employment for the people of the state and ensure their welfare, trade enhancement by providing all facilities under one roof, urban development, infrastructure already created like road, power station, power substation should not be wasted, and they argued only a portion of wetlands was to be affected and that economic necessity justified limited reclamation. The matter was first heard in court on 14 January 1992 by Justice Umesh Chandra Banerjee, who instantly passed an interim order prohibiting any change of land use. Court recognized environmental degradation as a social problem and recalled international conferences like Stockholm 1972 on the issue of protection of human environment, Vancouver the Habitat Conference in 1976, the World Water Conference at Argentina in 1977 on the water pollution. The court noted that unchecked urbanization and pollution pose long-term threat to human survival and emphasized the concept of intergenerational equity, the protection of an environment for future generation. Court also recognized the importance of East Calcutta wetlands. These wetlands are vital for maintaining microclimatic conditions, natural oxygen production, absorbing pollution from air. They also act as receptacle for rainwater and sewage, recycling wastewater naturally for efficient nutrient recovery through oxidation and pisciculture, providing low-cost fresh fish to the markets of Calcutta. The East Calcutta Wetlands is one of the largest natural waste recycling ecosystem in the world, acting as a spill basin to control flood, serving as habitat for aquatic flora and fauna, home to over 150 bird species, including migratory birds from Siberia and East Europe, employing thousands of rural people, maintaining ecological balance. The court also highlighted our responsibility as a contracting party to the Ramsar Convention, an intergovernmental treaty on wetlands. India is obliged to promote the conservation of wetlands habitat within her territory. The East Kolkata wetlands, then listed in the Directory of Asian wetlands, and it meets acceptable criteria for identification of an internationally important wetland, Ramsar site. So the opinion of the court was, while development is important, it must be balanced with ecological sustainability. The state government neither substantiated its claimed benefit of setting up a World Trade Center, nor presented any comprehensive or credible project plan. The question is not as simple as the city is losing a portion of its fish and vegetable supply from its backyards, but it is a question of social and economic cost benefit involving much larger and intricate issues. Justice Banerjee did not find any justifiable reason to disagree with the opinion expressed by the environmentalists that the wetland should be preserved and that no interference or reclamation should be permitted. The outcome of the proposal, the outcome of that the proposal for World Trade Centers were turned down in its original form and strict conditions were laid down. Finally, the verdict was out on 14 September 1992. The court finally imposed an interim injunction restraining the state governments from reclaiming any further wetland. It also prohibited the government from granting permission to any person for changing the use of land from agriculture to residential or commercial in the area indicated in the map annexed to the petition and marked with letter C. The court directed that the nature and character of the wetlands be maintained in their present form in order to stop all encroachment in the wetland area as shown in the map. And the state respondents are further directed to take steps to stop private alienation and if required to do so by extending the statutory provision in this regard. So after this judgment this judgment in 2006, West Bengal government framed East Kolkata Wetlands Conservation and Management Plan. But I'll discuss this in other video. But here you can see that the injunction for East Kolkata wetland was applicable in the map as per the map annexed with this proposal with the petition and market C. So I will see what was the map. So this was the map which was annexed as in the petition and marked as C, and you can see that this portion is the Dhapa area is garbage farms, and this is sewage treatment fisheries, and this portion is sewage farms, actually agricultural field which is irrigated by sewage water. In the petition there is another annexure which was marked as A, and it is a little bit better than the previous one. You can see the three distinct regions. One is garbage farm, second is sewage treatment fisheries, and third is sewage farms. But my point is here that this is not written anywhere that the area or the boundary of the area. So it is just a map which shows that this is the upper area with sewage, uh, which is the garbage farms, and this is the sewage treatment plant and the agricultural land or sewage farm. But there is some boundaries and lakes, uh, roads are given, so we can get a conceptually that this is a part of East Kolkata Wetlands or waste recycling region. But after now, the ecological importance of East Kolkata wetlands began to be recognized in early 1980s. Then when the government of West Bengal undertook a study to assess the wetlands area and traditional practice using Calcutta sewage. In 1985, the State Planning Board prepared a map of East Kolkata wetlands and recycling region covering approximately 12,500 hectares, and in 1992 the area was given legal protection for conservation through this landmark judgment by the Calcutta High Court. So you can see that before the judgment has come in 1990s, some research activities, studies for identifying the area of East Kolkata wetlands, assess the wetlands area and the traditional practice using the sewage water, Calcutta sewage water, that was actually going on, and a map was published in 1985 by the State Planning Board. And here in this map you can see that 20 plus this is 6 and this 5 and 1, so 32 mojas are written here, and you can see this is partly or fully moja covered. And this map actually the area where legal protection for conservation was given by the by the by the judgment in 1992. So after 10 years of this judgment, in 2002, East Kolkata Wetlands was included in the Ramsar list of wetlands of international importance. And in 2006, East Kolkata Wetlands Conservation and Management Act was formulated to provide conservation and management of East Kolkata wetlands. And in the East Kolkata Wetlands Conservation and Management Act, total number of moja is 37. But here you can see that the judgment were given, it is the area covering 32 moja partly or in full. So someday I prepared a video, is there any difference between 32 and 37? So that's all for today. You can go through the judgment or some of the articles, books I have written here for your further reference.